Senator Dalphond. So that was the first interruption. I hope there won't be. I was saying that the initiative for this bill came from the Honourable Rana Ambrose when in 2017. She saw it as a way to restore the confidence of victims of sexual offences, the majority of whom are women, in the Canadian justice system, which had been undermined by unacceptable comments made by some judges in high-profile cases. When I say unacceptable comments, I am referring to comments that indicate stereotyping, prejudices, or a poor understanding of the state of the law with respect to sexual offences.
And stereotypes include the following: that women who choose to go home with a man are necessarily consenting to sexual activity, that women who dress provocatively or are flirtatious are asking for it, or even when they say no, that women who do not resist are consenting, that women cry rape after a consensual sexual encounter that they later regret, and that women who have consented to sexual activity also consent to subsequent sexual activity. Prior to 1983, when Canada overhauled its laws on sexual offences, these myths not only infiltrated our courtrooms, they informed the very laws that govern sexual offences, and in some cases, even constituted rules of law. For example, a woman had to raise a hue and cry immediately after an alleged sexual assault if they were to be believed. A woman's allegation of sexual assault had to be corroborated if they were to be believed, and a sexual active woman was considered to have been more likely to consent to sexual activities, even if unsolicited. When the existing sections 275, 74, and 277 of the Criminal Code were enacted in 1983, all of these rules had to be specifically abrogated. But this didn't mean that they were automatically erased from the brains of all lawyers, counsel, police officers, and even judges across Canada. The 1983 amendments, together with reforms that were enacted in the 1990s, and most recently in 2018, through former Bill C-51, have responded to many persistent myths and stereotypes. We now have an affirmative consent sexual assault model in place in Canada, an approach that is respected around the world as one of the most robust responses to this type of crime. Now, most Canadians should know that no always means no, and a lack of consent always means no. Bill C-51 made also clear that advanced consent to sexual activity is not valid, and that consent must be continued and remain present through the sexual activity. Sexual activity cannot be engaged or continued with a person who is momentarily unconscious or unable to give consent for whatever reason. Finally, Bill C-51 strengthened existing procedural rules that protects victims of sexual offences from having certain type of evidence about them used to impugn their credibility, such as questions about previous sexual partners or activity. And yet, despite this strong legal framework and clear guidance from time to time from the Supreme Court of Canada, we still see the same myths and stereotypes influencing court decisions. À cela, il faut ajouter que les
Furthermore, victims do not always feel listened to in police stations where allegations of sexual assault are reported. In 2014, the General Social Survey on Victimization, conducted by Statistics Canada, victims of sexual assault reported a lower level of trust in the police than the population in general. In addition, the justice system appears to be slow and complex, and where some believe that accused persons are treated better than victims. Some also complain about the lack of support for victims in the process. Finally, in the case of sexual offenses, there are generally no witnesses, and often the outcome of the judicial process depends on the credibility of the person who filed the complaint. This may be seen as the trial of the victim rather than the accused, who has a right to silence, and a re-victimization of the person who made the complaint. This mixture of facts and perceptions about the justice system may doubtlessly deters many victims from seeking assistance from the police and the courts. Still, according to the 2014 social survey, only 5% of sexual assaults are reported to the police. The most frequently cited reasons for not reporting a sexual assault are feeling unbelieved, shame or embarrassment, not realizing that a complaint can be made, and lack of family support. This explains in part the Me Too phenomenon on social networks, where it is generally safe to report the perpetrator of an assault. This form of mob justice, however, offers no guarantee of truth-seeking, since it is not subject to an examination of the facts. It is in this context that the Ambrose Bill was introduced in the other place. At the committee stage, the Status of Women Committee proposed a number of amendments, the most important of which was the addition of social context as a topic that should be included in judicial education, in addition to judicial education on sexual offenses. The bill was unanimously adopted at third reading, all political parties seeing it as a way to avoid certain trials going off track. The comments of the MPs, however, show that they were well aware that the Ambrose Bill was only a step, albeit an important one, but not sufficient to encourage victims to use the justice system. When the Ambrose Bill arrived in the Senate on May 16, 2017, it did not receive the priority and procedural advantages reserved for government bills. As a result, it progressed slowly through second reading, a process that lasted a full year. Debates revealed that senators, many of whom are no longer with us today, expressed concern about various aspects of the bill that they considered either excessive or contrary to the principle of the institutional independence of the judiciary.
Have a robust and independent judiciary. A core constitutional principle underlying our democracy, judicial independence, means that our judges need to be free to decide each matter on its own merits, and that courts should manage their affairs without external influence. Judges must not be subject to interference or influence of any kind. Particularly relevant to our discussion today, judicial independence requires that the judiciary retains control over the management of its affairs, including the discipline and training of its judges. Le projet de loi sera finalement envoyé au Comité des affaires.
The bill will finally be sent to the Legal and Constitutional Affairs Committee on May 31st, 2018, where it will have to wait 12 months before finally being considered by the committee, where the Honourable Ambrose, the Honourable Andrzejczyk, representatives of the National Judicial Institute and the academic community were heard amongst other witnesses. Thanks to the collaborative efforts of many, including the sponsor of the project, former Senator Andrzejczyk, and former Senators Joyal and Prat, it was possible to unanimously agree in committee on amendments to the preamble and content of the bill. Unfortunately, despite my best efforts, I was unable to obtain third reading of the bill before the end of the previous Parliament. in June 2019. However, support for the bill has not disappeared, and political parties have promised to return to the issue after the election. On February 5, 2020, the Minister of Justice, the Honourable David Lametti, tabled a government bill in the Commons. This time, a government bill that incorporates the Ambrose Bill as amended by the Senate Committee on Legal and Constitutional Affairs. This bill made its way quickly to the House of Commons Justice and Human Rights Committee, which heard from representatives of the judiciary, the bar, and organizations providing support to survivors of sexual assault. Then, the pandemic struck, interrupting the committee's work before it could prepare its report, followed by an extension in August 2020. That's the end of the second attempt. On September 25, 2020, Minister Lametti reintroduced the bill, still entitled C-3. This third attempt will result in a short parliamentary committee study with no additional witnesses to those heard during the previous session. This new committee has made a few changes, the most important of which is to clarify that the social context includes systemic racism and systemic discrimination. Then, Bill C-3 was unanimously adopted once again at the in the House of Commons and is now before us once again. Honourable colleagues, that completes the story.
Of the bill. The Ambrose Bill provided that any prospective appointee to a federally appointed provincial superior court was required to have completed an up-to-date and comprehensive course on sexual assault law and social context prior to the appointment. In short, it was a condition that had to be met before submitting one's application, which implied the availability of suitable courses given by the law societies or other organizations, and the ability of the commissioners for judicial affairs to evaluate the completion of that criteria. De plus, il créait divers.
In addition, it set out various new obligations for the Canadian Judicial Council, an entity created by the Judges Act, composed of the Chief Justices and Associate Chief Justices of each of Canada's superior courts, and whose operations are, including the federal courts, and whose operations are funded by Parliament, which distributes no less than $30 million per year.
These obligations included the requirement to report annually on the number of sexual assault cases brought before the court by judges who have never participated in sexual assault training. This was a clear form of interference in court management. Finally, the Ambrose Bill dictated to the Council the content of the training to be given to judges, including who was to be involved in the development of the courts.
Compromising judicial independence. Fortunately, the Senate Committee on Legal and Constitutional Affairs addressed them. That said, like the Ambrose Bill, Bill C-3 is aimed at the fundamentally important objective of ensuring that survivors of sexual assault trust the criminal judicial system and that decisions in sexual assault proceedings will be rendered according to the law, the facts, and without resorting, conscientiously or not, to stereotypes, myths, and bias. To this end, the bill amends the criminal code to require of all judges that they explain in their rulings the reasons why a person was acquitted, found guilty, discharged after having been found guilty, found not criminally responsible on account of mental disorder, or found unfit to stand trial. This will allow the complainant, the accused, litigants, the media, and appellate courts to fully understand the reasoning of the deciding judge including the reasons that led to the conclusion that he or she reached, to ensure that they are not only legally sound conclusions, but they are also devoid of bias, stereotypes, and myths. The duty of transparency is very important to maintain confidence in the justice system. But I would add that the duty to provide reasons reduces the risk of error and the likelihood of an appeal and a retrial, which require the complainant to testify again and to relieve traumatic events. In sum, when Canadians interact with our courts, they should be confident that they will be treated with dignity, respect, and understanding. Survivors of a sexual assault should be able to trust that the facts will be appreciated without bias or through the lens of stereotypes, that the law will in this area will be carefully and properly applied, and that they will have access to reasons for the decisions in their case. That is what Bill C-3 amendments to the Criminal Code, applicable, I repeat, to all judges across Canada, provincially or federally appointed, will contribute to achieve. This should increase trust and confidence in our justice system, improve transparency, and make our courts more responsive and inclusive of all Canadians.
We must also help the courts to do things right the first time. Clearly, passing amendments to the Criminal Code is not enough. We need to ensure that judges, lawyers, and police officers have a clear understanding of the law related to sexual assault, the impact of sexual offenses on victims, and the social context in which these offenses occur. For this reason, the bill also proposes to encourage providing the best possible training to judges appointed by the Government of Canada. To this end, the bill amends the Judges Act, an act governing the process for the appointment of provincial superior court judges, the remuneration and other benefits of all federally appointed judges, their education and discipline.
Judges Act to limit eligibility for appointment to provincial superior courts to individuals who agree that after being appointed, if appointed, they will participate in training on sexual assault law and social context. This measure will ensure that judges newly appointed to provincial superior court start their judicial career with this critical training. Ensuite, le projet.
Next, the bill invites the Canadian Judicial Council to develop training on sexual assault law issues in consultation with individuals, groups, or organizations that the Council considers appropriate, such as survivors of sexual assault and groups and organizations that support them, and to offer these courses to all judges, new and those already working in the field. It should be noted, Madam Speaker, that the Council develops these courses with the assistance of the National Judicial Institute, an independent, not-for-profit, judge-led organization that is the primary provider of education for judges in Canada. Thanks to the dedication and efforts of the Council and the Canadian Judicial Institute, Canada is a leader in judicial education.
C-3 focuses on two particular areas of judicial education: training in matters related to sexual assault law and training in social context, including systemic racism and systemic discrimination. As I have said earlier, when speaking about the legislative background of the bill, the law relating to sexual offenses has been amended often since 1983. Various amendments were made in view of protecting complainants against discriminatory or unfair rules and practice, intrusive and irrelevant lines of questioning, limiting searches in complainants' medical and other files, defining consent, and so on. Unfortunately, as a result, Some provisions of the Criminal Code have been made longer and more complex, increasing the risk of mistakes by counsel and judges. To reduce the risk of error in law, the bill invites the counsel to provide more training about sexual offences law and judges to take advantage of these courses. Each year, approximately $6 million of the $30 million provided to the counsel by taxpayers are dedicated to the training of judges. On the topic of social context, I'll say that every individual exists in a social context made up of the various factors that intersect to impact the individual's experience, reality, and perception of the world. These include poverty, gender, gender identity, disability, or historical mistreatment, such as that experienced by indigenous peoples. Social context education addresses all of these issues, both singularly and through their intersection, and it is designed to teach awareness and skill for judges to ensure that all people are treated with dignity, respect, and importantly, equality before the courts. Systemic racism and systemic discrimination can impact on individuals' access to employment, public housing, economic opportunity, and on the delivery of public services such as healthcare and justice. For many people, particularly Indigenous peoples and Black and racialized Canadians, systemic racism and systemic discrimination are live realities and in the justice systems and far beyond, as was highlighted last June during our emergency debate on systemic racism. Canada has a strong legal and policy framework in place to address systemic racism and systemic discrimination. This framework includes the Canadian Charter of Rights and Freedoms, federal and provincial human rights statutes and codes, the Criminal Code, and the Canadian Multiculturalism Act, as well as other legislation. Section 15 of the Charter, for example, prohibits discrimination by all levels of government. The Canadian Multiculturalism Act recognizes and promotes the cultural, racial, and religious diversity of the Canadian society and acknowledges the freedom of all members of Canadian society to preserve, enhance, and share their cultural and religious heritages. The Criminal Code requires judges to consider for the purpose of sentencing whether a crime committed was motivated by bias, prejudice, or hate. These are useful tools in combating systemic racism and discrimination. Yet, for these tools to be effective, they need to be properly understood and properly applied by a justice system that is aware of social context, including the social context of the judge, and responsive to the experience of each individual that interacts with the courts. Bill C-3, Requirements for Judicial Education on Social Context, is part of the efforts made to address these issues. The inclusion of systemic racism and systemic discrimination in the definition of social context education is intended to highlight the importance that Parliament places on ensuring its pernicious and destructive impact is recognized and addressed. Going to court can be stressful and challenging. When Canadians interact with our courts, they should not bear the increased stress of confronting harmful myths and stereotypes. Nor shall they face a system that lacks awareness of their social context, including the ways systemic racism and systemic discrimination may impact on their lives. Social context training for judges aim to develop the skills and awareness that judges need to ensure that everyone who interacts with the courts is met with a responsive, respectful, and inclusive justice system. In addition to in-court interactions, Social context training is relevant to judicial decisions. Personal or societal bias, myths, and stereotypes have no place in judicial decision-making. Training in social context will continue to provide, as it does already, but will ever be strengthened, and thus provide even more to judges the knowledge and the tools they need to ensure that decisions are free from those inappropriate considerations. During their careers on the bench, judges interact with individuals who highlight the richness of Canada's diversity. Social context trainings provide judges with the skill, knowledge, and awareness to help them ensure that courtrooms are welcoming to this diversity and responsive to it. Bill C-3 social context trainings requirement assures Canadians that their newly appointed Superior Court judges and those long-serving judges will receive and will be provided access to proper training and tools to do their important job.
Concerns have been raised about amendments to the Judges Act related to judicial education. In my view, this is wrong. Bill C-3, as now drafted, fully respects the independence of the judiciary. It is carefully designed to balance the need to enhance public confidence in our justice system with the need to preserve full judicial control over the education of judges. The requirement for judicial candidates does not apply to sitting judges. Rather, it is an additional condition of employment for the position in order to better serve Canadian litigants. As for the invitation to the Judicial Council to ensure that training is available to all judges, this is not new. Indeed, the judiciary has long understood that continuing education is something to be encouraged. The function of the judiciary requires not only good training and ability to listen and empathize, but also, as with all other professions, the duty to keep up to date and improve one's skills. In a document entitled The Ethical Principles for Judges, adopted by the Canadian Judicial Council for federally appointed judges, states that, and I quote, "An important aspect of diligence is the constant desire to enhance the knowledge, skills, and abilities necessary for good judgment. This obligation requires that judges participate in continuing education programs and pursue personal study." End of quote. The document also refers to the duty of judges to, and I quote, "make every effort to identify attitudes based on stereotypes, myths, or prejudices, to be sensitive to them and to correct them." End of quote. So, Parliament is just supporting the measures of the Council and continuing along the same lines. This has led some people to say that it is not necessary to deal with it in the statute, since it is already part of the reality of judges. But what is wrong with Parliament, which authorizes funding for judicial education, highlighting to the Judicial Council and to the judiciary as a whole the importance of this issue to all Canadians? Indeed, Parliament has as much interest as the Judicial Council in encouraging the continuing education of judges in order to maintain and even increase the confidence of litigants in our courts, important elements of our system of governance as a country, without which true democracy cannot exist.
Through a further amendment to the Judges Act, this bill invites the Council to submit annual reports to the Minister of Justice on the social context and sexual assault law seminars and courses provided in the previous year. These reports will include a description of the content covered in each seminar or courses and the number of judges in attendance. Upon receipt of such report, the Justice Minister will be required to table it before each chamber of parliament. Cette invitation
This invitation to report on the Council through an annual report, which is then submitted to the Minister of Justice, a copy of which is tabled in both houses, it must be understood that this is not a way of ensuring transparency, but it is rather just a suggestion. The words in the Act as amended by the House highlight this. It is, however, a way of ensuring transparency by a council created by an act of the federal parliament and financed entirely by funds allocated annually by Parliament. I would remind you that the council's annual budget is $30 million, $6 million of which is for judicial education. In addition, the government has been authorized by Parliament in Budget 2019 to increase the funding for judicial education by $5 million over the next 10 years. Judicial independence is fundamental, but it is no justification for a lack of accountability for the use of public funds, as indeed is the case with judicial expenses and fees, which are now made public quarterly. Moreover, it is appropriate for the Council to explain to Canadians its operations, its objectives, and the courts as a whole, the courses it provides to judges in order to provide Canadians with the best possible service of justice. Not only can we talk about transparency, which is always necessary when we talk about the use of public funds, but I also see it as an opportunity for the judiciary, which is bound by a duty of reserve, to communicate to the general public information that can increase Canadians' confidence in our justice system. It is therefore a platform that we're offering to the judiciary rather than an obligation. Finally, I would like to reiterate that the language used was modified by the Justice and Human Rights Committee to make it clear that this was not an order of the Judicial Council, but rather an invitation to provide information, all in order to reflect Parliament's respect for the independence of the courts and the administration of justice, as stated in the preamble to the bill, which reads as follows, and I quote, "Whereas Parliament recognizes the importance that should be accorded to judicial independence," end of quote. In closing, Honourable Senators, I am pleased that the important work done by the Senate in 2019 has been incorporated into this bill. Once again, the Senate is demonstrating its usefulness as a chamber of reflection and analysis, and as a guardian of the major principles set out in our Constitution, in particular the separation of powers and the necessary independence of judges and the courts.
It is long overdue that the legislative story of this bill gets its happy ending. A Parliament adopts this bill designed to enhance the trust of survivors of sexual assault in the judicial system. It will acknowledge that they deserve to be treated by judges that know very well the law and are able to guard themselves against myths, bias, and stereotypes while deciding sexual offences cases. Thank you. Merci. Miigwech.